Welcome back, Consumer Law 101 students and scholars. My name is Aaron Swift, attorney, CEO, and managing partner of Swift Law North and Consumer Law 101. Today we are talking about the truth about debt verification and validation under the FCRA. All right, first let's look at the agenda. We're going to first talk about why is this so important, such that truth is capitalized in the title of this lecture video. Then we're going to have a brief discussion about the intersection between the FDCPA and FCRA. Then we're going to dispel so-called validation techniques. And lastly, as we always do, we're going to make a connection between this topic and litigation-backed credit repair so that our viewers, Consumer Law 101 scholars, can use these tools effectively going forward. Okay, so first of all, I wore all black on purpose because I feel like I'm the Grim Reaper or the Undertaker here. I'm about to kill a lot of dreams, a lot of hopes, blow a lot of minds about this topic in particular. Most credit repair organizations, so-called credit experts, and almost all consumers, they misunderstand and they misuse debt verification and validation letters. And then that confusion leads to a lot of unhappy clients, a lot of chargebacks, a lot of money back guarantees that cannot be met because of this confusion. And there are so many false prophets here in this space. I've said that before, I'll say it again. It's a lot of false information, a lot of do-it-yourself tools being sold and used that just aren't worth, the paper they're written on. And then even dispute software that all get this wrong. All right, so before I really tear down this scheme, let's talk about the intersection between how these concepts work under the FDCPA, the Fair Debt Collection Practices Act, and the FCRA, the Fair Credit Reporting Act. So first of all, since you're here in the second lecture video series, you've already gone through the FDCPA topics, and you will have learned about debt verification and validation, but we're going to talk about that again. The FDCPA, the Fair Debt Collection Practices Act, it has certain requirements and certain rules and regulations that apply to third-party debt collectors. Some of those regulations involve what information a debt collector must give when they're communicating with a consumer, not only the first time they communicate or within 5 days, but then so on and thereafter by basically telling them you're a debt collector and any information will be used for that purpose. I'm sure we've all heard that. It's kind of called the mini Miranda under the FDCPA. But what do debt validation and verification letters, have to do with the FDCPA and how does that work? Well, like I said, the FDCPA has requirements on debt collectors. And one of them is within the first 5 days or in your first communication. So if you call someone, you have to give this information within 5 days of that. But usually debt collectors, the first communication is in a letter. And then that first letter, they're pretty standardized now, especially after new Reg F changes, but we've all seen them, right? It has a whole bunch of sections, and then it gives this disclaimer. It talks about them being a debt collector, and here's the key. That's what lays out what's in that first communication, and also in the statute itself, the debt verification and validation rights under the FDCPA. Again, please understand this. If you take nothing else, well, take a lot of stuff from this series, but this topic in particular is so important. The FDCPA only allows the debt verification and validation rights to exist within those first 30 days. 31 days and thereafter, it doesn't matter how many times the consumer requests verification and validation, demands it, sends up smoke signals trying to require it, it doesn't matter. The whole purpose is you don't know these third parties, or consumers don't know. They didn't contract with them. If you fall behind on a car loan and a new debt collector's on the scene, you may never have heard from them. So when they contact you, they have to tell you who they are and what they're doing. And then they have to give you certain rights. But those rights are limited to, again, that first 30 days after the consumer receives that letter that breaks down those rights. And it says you have the right to dispute, this debt or any part thereof. That's certainly one of the important parts of the disclaimer. It gives you the right to request information about the creditor if the original creditor is different than the current creditor. You can ask in writing for certain information. But again, it's limited to within the first 30 days after receipt of that communication. After that, it doesn't matter. Nothing else gets triggered. If and when a consumer or someone on behalf of the consumer does properly request verification or validation within that 30 days, then things do have to happen. They must follow the statutory requirements and give the information that the disclaimer requires. But after that, it doesn't matter. Okay, so what does that mean in context? It means that debt verification and validation under the FCRA, the Fair Credit Reporting Act, is incredibly weak. And why I say that is it only ever applies at all if those actions are taken within the first 30 days of when the third-party debt collector came on the scene, and that's specifically laid out in the Fair Debt Collection Practices Act, the FDCPA. The FCRA is silent on that issue. There's no such thing as debt validation and debt verification under the FCRA. There's no requirements under the FCRA to put certain, regulations or disclaimers in writing, not in terms of validation or verification. The FCRA has its own host of other, written obligations that we'll talk about in a lot of these video series, in fact. But in terms of verification and validation, it doesn't mean anything. Okay, so, well, again, not that it doesn't mean anything, but if it's not done within the first 30 days of the debt collector coming on the scene, it doesn't matter because it doesn't trigger any rights. All right, so what does all this mean in context again? Here's what I call the so-called validation and verification dispute setup. And I call it a scheme because that's kind of what it is. What happens is a credit repair company, a consumer themselves, someone gets software, buys a template online, and this is well after the first 30 days of a debt collector coming on the scene, but there's collections and trade lines from junk debt buyers on the consumer's credit report. So what happens? They start sending out demands for validation and verification. And I've seen those letters that have a whole host of crazy things, demanding every piece of paper ever. I demand you to prove every charge on this account was me. I demand the credit card application with my signature. And if you can't prove it, then I don't owe you money. Again, they mean nothing under the FCRA if they happen outside the first 30 days of the debt collector coming on the scene. And it is a common scheme. Credit repair companies sell this lie all the time that if I demand this of them or I request this of a third party and they don't do it, well, guess what? That means they can't verify and they can't validate it, so they must delete it from my credit report. That is 100% false. Why it doesn't work is because there's no foundational principle under either statute that allows a credit repair company to do that or a consumer to do that. The law does not require that if a debt collector does not properly does not respond to a validation and verification request, that again happens outside the first 30 days of a debt collector coming on the scene, it doesn't matter. They don't even have to respond to it. If they don't respond to it, that means nothing. It doesn't mean it has to be deleted. It doesn't mean the consumer doesn't owe the money. Sometimes they do respond, but they certainly don't have to. First party, creditors certainly don't have to in most states or in all states. And then third party debt collectors, if it's not within the first 30 days, they don't have to respond. And their lack of response or their failure to respond does not mean the debt's not owed, and it certainly doesn't mean that it must be deleted from the credit report. No matter how many quote unquote validation requests were sent in after the first 30 days, they can 100 days in a row ignore 100 of them because it doesn't matter. And that is one of probably the most common credit repair schemes out there, other than some other ones that involve, disputing everything as fraud, erroneously or with bad intentions. But validation and techniques, it's not true. It's a bag of goods that doesn't have any value. Consumers are being ripped off. Credit repair companies are getting bad information from other so-called experts. Again, this is so important. It just doesn't work because there's no foundation within the statutes. Now, it's not to say, again, we've talked about this before, that after 30 of these letters are sent back and not responded, that a dispute could work. Because again, disputes can work. They can slip through the cracks. A dispute agent can do the wrong thing. But just because it works doesn't mean the technique that caused it was right. And again, in this case, any type of validation, verification, so-called scheme just doesn't work because it's almost always going to be after the first 30 days. Most consumers aren't in a position to start paying for credit repair services, until they're pretty far behind the 8 ball and they have no other choice. And by that time, a lot of these accounts have been parked on credit reports for years, certainly more than 30 days after the debt collector came on the scene. So how does this connect to credit repair and litigation-backed credit repair? This is the reason why litigation-backed credit repair is the real deal. It's why it's the only and most proven method, because it doesn't rely on false techniques. Again, just tying back to this topic, you could, until you're blue in the face, write as many demand letters suggesting or requiring, give me proof of my signature, I demand validation, verification, and if they don't respond, or even if they do respond and don't give you what you want or what the credit repair company requested, it doesn't matter. It doesn't have to be deleted. It doesn't mean the consumer doesn't owe it. In fact, it means very little to nothing, other than if it happened within the first 30 days, the debt collector has to respond as the FDCPA requires. But instead of using those techniques that don't work, or that may work just by luck or happenstance, if you really want credit repair to work, it has to be done this way. You have to have a litigation-backed strategy, because the backing of all of this are laws, and those laws have litigation at their heart. So if you want to learn how to get more debt forgiveness, trade line deletions, happier clients, visit us on the web, consumerlaw101.com, swiftlawnorth.com, and keep watching our videos. Thank you.